Hello everybody, Martin Radner here from Radner Law Group, bringing you trial analysis. Today we are going to be jumping into the petition for a writ of prohibition that the Alex Murdaugh defense team filed in the state of South Carolina Supreme Court. So, as you'll all remember, there was an appeal filed originally in the Alex Murdaugh case, and then the Alex Murdaugh defense team had to file a motion to stay the appeal. So we have the trial court level over here, you've got the Court of Appeals up here, you've got the Supreme Court above the Court of Appeals. So the trial court, after the trial court was done, after the jury trial was done, sentencing was done, the Murdaugh team filed an appeal. So now, while the appeal was going on, that's when they discovered all of this this alleged jury tampering by Becky Hill, and therefore they filed a motion to stop the Court of Appeals from hearing the appeal, stay everything, stop and send it back to the trial court level, so that now they can file a motion for a new trial in the trial court level. Well, now they file this petition in the Supreme Court. So how is this all working? This could just drive somebody crazy. Well, how does this all work? Well, the way that this works is that there's a special court rule. Yes, you're right. Generally speaking, only one court has jurisdiction over a matter. So as long as that court has jurisdiction over that matter, the only place to file anything is in that court, which is why when the Court of Appeals had jurisdiction over this appeal, that means the whole case now is in the Court of Appeals jurisdiction. The Murdaugh team had to file a motion to stay the appeal and send it back to the trial court level so that they can file this motion for a new trial. That's what they did. But now, all of a sudden, they're filing this petition in the Supreme Court. So how does this work legally? How does this work? Well, there is a court rule. Of course, for every rule, there's an exception. So the rule is 245 in the South Carolina Appellate Rules. And 245A states the following. The Supreme Court will not entertain matters in its original jurisdiction, which means you can't just go file anything that you want for the first time in the Supreme Court level. The only way to generally get to the Supreme Court is if you go levels. You start off in the trial court, then you go to the Court of Appeals, and then you get to the Supreme Court. And here, how is the Murdaugh team able to jump from the trial court level to the Supreme Court? Well, this is the rule. So the rule says, generally speaking, you're not allowed to do that, right? When the matter can be determined in a lower court in the first instance without material prejudice to the rights of the parties. If the public interest is involved, or if special grounds of emergency or other good reasons exist why the original jurisdiction of the Supreme Court should be exercised, the facts showing the reasons must be stated in the petition. So there is an exception. The exception is if you have really good reasons or an emergency, or if the public interest is involved. So if you have a really good reason and you lay it out in a petition, then the Supreme Court could have a regional jurisdiction, meaning that you can start your issue with the Supreme Court right away. And the basis for this petition is actually 245B, which is labeled extraordinary writs. A party seeking the issuance of an extraordinary writ. Now, what's a writ? Let's stop the guns for a second. What does a writ mean? You know, we hear all these different legal terms. Well, a writ is very simply, it just means an order. You're asking the court to order something. Why are you calling it a writ? Because we want to confuse people. So that we always have to, throw different terms around so that lawyers can sound smart and that general people don't know what they're talking about. No, it just means an order. That's all a writ is. So essentially, that's all it is. There's some slight differences, but the point, it's really, they're just asking the Supreme Court to order something, okay? So you are allowed to do that if you file a petition. So that's essentially what they're doing. So they're filing this petition and showing, using case law, why the Supreme Court now has original jurisdiction over this matter, and that they should order something that the trial court should do. Okay, that's what they're asking for. Now, what are they specifically asking for? They're specifically asking that Judge Newman, Judge Clifton Newman, should not be allowed to preside over this motion for a new trial, preside over the evidentiary hearing, which most likely is going to happen, and if a new trial gets granted, to be able to preside over that new trial. So that's what they're asking. They're asking that the Supreme Court should make an order and tell the trial court level that we need a new judge to hear the motion for a new trial, we need a new judge to preside over the evidentiary hearing, and we need a new judge in case a new trial gets granted to preside over that trial. What's the basis for this motion? Now, there's a 25-page petition that they filed. And of course, just like we always do, we're not going to spend an hour and a half going through every page and explaining it forever. We're going to just cut through the weeds. We're going to give you what you need to know, the main parts of this, the important parts of this, so that you can really know what's going on and give you a good feeling what's going on in a quick and simple, succinct way. Please, if you haven't yet, subscribe, like the video so we can continue bringing this analysis to the people that are looking for it. So, starts off like this. Now, you have to understand that there's something called the Code of Judicial Conduct, okay? The same way that lawyers have rules of professional conduct which they have to abide by. So aside from attorneys, let's say, aside from attorneys taking the bar exam, there's also another exam that attorneys have to take. It's an exam that has to do with rules of professional conduct. And that's something that we all have to abide by. There's certain specific rules for how we're allowed to conduct our practices, certain laws about how we're supposed to interact with clients, things like that. So there's certain rules of professional conduct that we all have to abide by. So a judge is no different. A judge has specific rules. They're the Code of Judicial Conduct, which requires judges to act in a certain way as a judge. So they are alleging, the Murdaugh team's alleging, that Judge Newman violated a number of these of the codes of judicial conduct, which the violation of requires that this judge be recused and not be allowed to hear. It disqualifies him from presiding over the issue in which he showed that he violated the Code of Judicial Conduct. So let's take it step by step. The first argument they make is that, first of all, you have to understand that this is what Murdaugh is saying, the Murdaugh team. Judge Newman has personal knowledge about the clerk of court's alleged misconduct. We all remember that the allegations here are that Becky Hill, the clerk of the court, tampered with the jury. And the Murdaugh team is alleging that Judge Newman has personal knowledge about this misconduct that the clerk of court engaged in. And this is what the Code of Judicial Conduct states. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has personal knowledge of disputed evidentiary facts concerning the proceeding. If the judge has personal knowledge, the same way that a lawyer cannot be a witness on the case that he is acting as a lawyer on, so too, if a judge has personal knowledge of the disputed evidentiary facts are surrounding this issue, he is not allowed to preside over that hearing. And they continue and they say like this. They say that Miss Hill, Becky Hill, told Judge Newman about a Facebook post. This whole Facebook post, everyone remembers that it was a questionable, was this Facebook post ever posted? Was it by this juror's husband or was it taken down? Was it not? All of the facts surrounding that was clear that there was statements made to Judge Newman, and there's conversations between Judge Newman and his law clerk and the clerk of the court about this juror's alleged Facebook post by her husband. So, and this is something that they mentioned also. They mentioned that Miss Hill certainly will be a witness, and she will be asked about bringing the Facebook issue to the attention of Judge Newman. Meaning, one of the questions that the Murdaugh team is going to be asking Ms. Hill during these evidentiary hearings, which are going to result from this motion for a new trial that was just filed, right? There's going to be an evidentiary hearing. Ms. Hill is going to take the stand. They're going to be asking Ms. Hill about these Facebook posts, and they're going to be asking Ms. Hill, did you speak to the judge about it? Now, what happens if during her testimony she testifies falsely about what she told Judge Newman? Now, Judge Newman might be sitting there and he might know that she's lying. What is he supposed to do in that situation? This is what the Murdaugh teams are arguing. What's Judge Newman supposed to do? Let's say he knows for a fact that she's lying. Is he just supposed to, here's what they say. Would he simply announce that her testimony is incorrect? Would he make a finding of fact based on personal knowledge that contradicts sworn testimony on the record? Such questions are why judges have personal knowledge of disputed evidentiary facts must disqualify themselves. So therefore they're saying, number one, is that Judge Newman knows too much about this whole Facebook situation and what Ms. Hill told him and what was going on with all these conversations that happened. He's a witness. He's essentially a witness. So he can't obviously be the judge while Ms. Hill is taking the stand. That's their first argument. Here's their second argument. Second argument is that there's another code of judicial conduct. And this is, the judge shall not commend or criticize jurors for their verdict other than in a court order or opinion in a proceeding, but may express appreciation to jurors for their service to the judicial system and the community. So generally speaking, after a jury trial, after the verdict is read, the judge will always say, we'd like to thank you, or I would like to thank you for your service, and it plays such an important part of our system, and things like that. That they're allowed to do. But they're not allowed to commend or criticize jurors for their verdict. They're not allowed to tell the jury, I don't know how you got to that verdict. That's the wrong verdict. Or they're not allowed to say, jury, you came to the right verdict. I'm very proud of you. You're not supposed to say that as a judge. You're just supposed to say, thank you for your service. We appreciate that you are paying attention. We appreciate that you are following the law. Thanks for your verdict. That's all you're allowed to say. You're not allowed to say, great job, you did the right thing. You're not supposed to say that. However, despite this rule, at sentencing, Judge Newman told the jury the following. This is what he said. I will make no comment now as to the extent of the overwhelming nature of the evidence, and overwhelming nature of the evidence. Also, the Murdaugh team makes a whole big deal about this word, this verbiage that Judge Newman used, overwhelming nature of the evidence. We're not going to get into it because it's a little bit weedy. It's a little bit on the side. It's not the strongest argument in the world. But the other part of the argument is actually a decent argument. And this is, again, so this is what Judge Newman says. I will make no comment now as to the extent of the overwhelming nature of the evidence, but certainly the verdict that you have reached is supported by the evidence, circumstantial evidence, direct evidence, all the evidence pointing to only one conclusion, and that's the conclusion that you have all reached. So I applaud you all. I applaud you for all, for as a group and as a unit and individually evaluating the evidence and coming to a proper conclusion. So this certainly sounds like he is applauding the jury for coming to a proper conclusion. So that, the Murdaugh team is arguing, violates this Code of Judicial Conduct, which states that a judge shall not commend or criticize jurors for their verdict. Okay, then they get into this overwhelming, the fact that he used the overwhelming word, and that has some significance in the law, that term of overwhelming, which means that even if there's an error, it shouldn't be reversed. Okay, we're gonna pass on with that. If you want to look at that, if you want to look at the petition and figure that one out, that's fine. But it's not. I don't think it's the strongest argument, so I'm just gonna move over that. Okay, number 3. So we got 2 strikes so far that they're arguing. Number 1, that he has personal knowledge about the whole Facebook situation with Becky Hill, and number 2 is that he complimented the jury for coming to a correct verdict, which is not proper under the Code of Judicial Conduct. Number 3, the Code of Judicial Conduct. A judge shall perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties by words or conduct, manifest bias or prejudice, which means that a judge cannot, just simply, can't act with bias or prejudice. If you don't like this guy in front of you, you have some bias against him, you have some prejudice against him, then you're not allowed to act with personal bias against this person. And that applies to throughout the trial, obviously, and also throughout the sentencing phase. So, this is pretty much obvious. A judge can't have personal bias against a litigant. And they argue that Judge Newman's comments at sentencing show personal bias regarding Mr. Murdaugh and his family. And another, what a judge is allowed to do during the sentencing phase is they're allowed to express views which are the general attitudes common to the public generally. And generally, the public doesn't appreciate murderers running around. So you can say how important it is to not have murderers running around. That you're allowed to say. But the minute that you make it personal, that's what the Murdaugh team is arguing, that if you make it personal against this specific individual and his specific family, then that's already beyond what you're allowed to do under this Code of Judicial Conduct. And they state, this is what the Murdaugh team argues, the court's outrage that Mr. Murdaugh presumed to defend himself is a manifestation of personal bias against Mr. Murdaugh arising from other acts that occurred years before the murders and from the prominence and privilege Mr. Murdaugh's family enjoyed and which Mr. Murdaugh abused. So they're arguing that the court pointed out that there is a history of corruption in the Murdaugh family, and he mentioned that during sentencing, which sounds like he's taking out the fact that he has this personal bias against the Murdaugh's history of not acting ethically, things like that, against Alex Murdaugh, in his sentencing. And this is what the example that they choose. This is what the Murdaugh defense team, what the example that they use. For example, Judge Newman stated at sentencing. This is what he stated. And you've engaged in such duplicitous conduct here in the courtroom, here on the witness stand. But amazingly, to have you come and testify that it was just another ordinary day, that my wife and son and I were out just enjoying life, not credible, not believable. You can convince yourself about it, but obviously you have the inability to convince anyone else about that. So if you made any such arguments as a lawyer, you would lose every case like that. So, what did he say on the witness stand? Well, on the witness stand, Mr. Murdaugh denied murdering his family. Now, that's allowed. You're allowed to deny the allegations against you. So, they argue, Judge Newman's comments do not express the outrage common to the public generally, but his personal outrage at how Mr. Murdaugh practiced law for many years, viewing Mr. Murdaugh's denial of murdering his family as a continuation of that dishonest conduct. So you're being dishonest in the courtroom, on the witness stand, and that is also how you've conducted yourself as a lawyer. So he's taking it much more, this is what they're arguing. They're arguing that you're taking this personally. You're making this much more personal against Mr. Murdaugh. And then he says, which is, again, this is not the strongest argument for the Murdaugh team, but then they argue the following, that the judge was actually taking it out on Mr. Murdaugh's ancestors, which I alluded to earlier. And this is what he said. Even during this trial, the law enforcement has been maligned for the past 5 or 6 weeks by one who had access to the wheels of justice to be able to deflect the investigation. That is what the judge mentioned. Again, even during this trial, the law enforcement has been maligned for the past 5 or 6 weeks by one who had access to the wheels of justice to be able to deflect the investigation. What does that mean? Judge Newman's comment, this is what they argue. Judge Newman's comment about being one who had access to the wheels of justice to deflect the investigation does not refer to him as a criminal suspect who failed to tell investigators the truth when interviewed. Nor does it refer to Mr. Murdaugh's sporadic service as a part-time unpaid assistant solicitor, in which he first chaired a single trial and second chaired 4 trials with his father over a 23-year period. It refers to Mr. Murdaugh's family as a symbol of corruption in the Low Country, and specifically to his father, grandfather, and great-grandfather serving as the solicitor in the 14th Judicial Circuit for 86 years. Judge Newman elaborated on that theme in his sentencing comments. And this is what he said, Judge Newman. And this case qualifies under our death penalty statute based on the statutory aggravating circumstances of 2 or more people being murdered by the defendant by one act or pursuant to one scheme or course of conduct. That's a very general comment. The comment is that if the murder was by of 2 or more people, which was pursuant to one scheme, then the person is liable for the death penalty. I don't question, this is continuing, Judge Newman continues, I don't question at all the decision of the state not to pursue the death penalty. But as I sit here in this courtroom and look around the many portraits of judges and other court officials and reflect on the fact that over the past century, your family, including you, have been prosecuting people here in this courtroom, and many have received the death penalty, probably for lesser conduct. And this is the argument that the Murdaugh team is making. What Mr. Murdaugh's grandfather or great-grandfather did in a courtroom before Mr. Murdaugh was born has no relevance to any issue in sentencing. What does his grandfather's arguments for the death penalty about somebody who committed some murder 80 years ago have to do with Alex Murdaugh's case in front of him? Judge Newman's discussion of Mr. Murdaugh's ancestors sua sponte. What does sua sponte mean? Sua sponte means unprovoked, on his own. He just pulled this out of his hat, Judge Newman. Judge Newman's discussion of Mr. Murdaugh's ancestors sua sponte is evidence of personal bias. And then they argue that the defense team has a duty to dispute the evidence. So this comment that Judge Newman made, that law enforcement has been maligned for the past 5 or 6 weeks, that's just the defense doing their job, essentially. So they're trying to argue, again, in this case, that there's been some personal bias because of the comments that Judge Newman made, and specifically, I think our stronger arguments are the comments that he made about the Murdaugh family, and has nothing to do with Alex Murdaugh himself. Don't throw him under the bus just because you don't like the way that his grandfather practiced law, right? So that shows a personal bias. So that's another argument. The next argument that they make, Judge Newman's extrajudicial statements after Mr. Murdaugh's trial violated Canon 3 of the Code of Judicial Conduct. So there is another Code of Judicial Conduct which they're alleging Judge Newman violated. A judge shall not, while a proceeding is pending or impending in any court, make any public comment that might reasonably be expected to affect its outcome or impair its fairness, or make any non-public comment that might substantially interfere with a fair trial or hearing. Any pending issue, a judge should not make a comment about that pending issue. So this is something that we hear about all the time. If you look at any of the hearings, the Senate hearings, and they're talking to potential judges and they ask them about certain cases, you always hear this answer that we can't comment on any pending cases. And that's true. No judge should give his opinion about pending matters. So that is a code of judicial conduct. And the commentary to that section provides that the requirement that judges abstain from public comment regarding a pending or impending proceeding continues during any appellate process and until final disposition. Judge Newman knew that they filed an appeal on this case. So therefore, he has no business giving any public comment about the proceeding, about the Alex Murdaugh case. And then they bring a case that says, some case law which says that when it does occur, it is almost universally found to be misconduct. If a judge comments on a pending matter, and that includes during the appellate process, it is almost universally found to be misconduct. So they argue here that shortly after Mr. Murdaugh filed a notice of appeal, Judge Newman gave an extended interview about Mr. Murdaugh's case at his alma mater, the Cleveland State College of Law. The interview was held in a law school moot courtroom and was open to the public. More than 300 people attended. It was streamed live on the internet, and the recording is still available. During the interview, Judge Newman expressed his personal opinions regarding Mr. Murdaugh's guilt. He said in there that there's no way that he'll be able to sleep peacefully. That's certainly commenting on his personal opinion about Mr. Murdaugh's guilt. Now, if Mr. Murdaugh wasn't guilty, he may not be able to sleep because, his wife is dead and his child is dead. But what Judge Newman was suggesting here is he's not going to be able to sleep because he was the one that did it. So this is an interview while the claim of appeal was pending. So that's another argument that they make. Okay, now they bring up this other issue, which was interesting and really not so much related to this motion, related to this petition, but I think it's interesting, so let's just discuss it for a minute. So one of the controversial, shall we say, rulings or orders of the court of Judge Newman was that he allowed all of this testimony regarding Alex Murdaugh ripping his clients off. And initially, they filed this motion. There's a motion that the state filed before the case that they wanted to talk about his financial crimes in support of its theory. And the theory was that Alex Murdaugh had a motive. Part of his motive was that he had such serious financial problems because of all the way that he was ripping off his clients and his law firm. So they filed this motion. Now, at the time, Judge Newman declined to rule on the motion. He didn't rule whether that evidence is going to come in. And everybody understands that having the jury hear about all of the clients that he ripped off could have an effect on how they will come out with this verdict, whether this verdict is going to be guilty or not. They keep hearing about how a terrible person he is, that he's just ripping people off and stealing from people. So then they're much more likely to say, okay, he probably committed the murder also. So everybody understands that this is a very important ruling. Now, he declined to rule on the motion. A lot of times the judges will do that. We'll say, well, let's see how the evidence comes out, and then we'll discuss it then. And then there was the following exchange. There was examination of Will Loving. Will Loving is a 25-year-old construction worker who was friends with Paul Murdaugh. On cross-examination, the defense counsel asked Mr. Loving about his observations of the relationship between Alex, Maggie, and Paul. And this was the back and forth. Question: and did you spend a lot of time with Paul around his dad and his mom? Answer: yes, sir, I did. Question: and how would you describe Paul's relationship with his father? Answer: it was an awesome relationship. Question: what do you mean by awesome? Answer: it just kind of seemed like Paul was the apple of his eye. Question: okay, and from your observations, would you tell the jury what you observed of Alex's relationship with Maggie? Answer: I thought that they had an awesome relationship as well, through everything that I can see. You know, they were always laughing and everybody got along, and nothing was out of the ordinary at all. So this is the defense counsel cross-examining Will Loving. Now, you see that that Will Loving is talking about the type of relationship that Paul had with his father and what Alex's relationship was with Maggie. And similar questions were asked of another friend of Paul's. So now here comes Judge Newman, and Judge Newman ruled those questions solicited character evidence. So the rule with character evidence, when are you allowed to bring in character evidence? So generally speaking, just bringing in character evidence is not admissible. You can't just say, the guy's a great guy. I know him. He's been such a great guy. There's no way he committed this crime. That's not admissible. But if you open the door on your side of the defense, you open the door and say you solicit testimony of character evidence because you want your client to come across as this genuine, wonderful person, well, then you open the door. And now the prosecution can now also bring evidence showing the opposite of that, showing that he does not have great character. So that's how the character evidence rule generally works. Of course, there's always nuances, and I'm not doing a deep dive into that rule of evidence, but that's a general concept. Okay. So because of this exchange, the Judge Newman ruled that he allowed the state to present weeks of testimony about unrelated financial crimes. So that's why the Judge Newman said, oh, once that came in, now we're letting in all of the financial crimes because now you open the door for his character. Now, this is really a serious question here, whether this constitutes character evidence or not. And certainly would be an appealable, a question on appeal about whether this is considered opening the door. Because he's not really asking about how is Alex as a person. He's asking about the relationship that Alex had with Paul and Maggie. And that goes directly to whether he would be in the state of mind to kill them. So it's not just character evidence. But regardless, that was Judge Newman's ruling. Okay, so they bring that up also, and continuing with this argument, they quote some other case law and code of conduct for United States judges that a judge should abstain from public comment about a pending or impending proceeding in any court. We know that Judge Newman also gave an interview on the Today Show. So, therefore, these comments that he made also, and these opinions that he gave, when there is an appeal still pending, the Murdaugh team is arguing that that was a violation of the Judicial Code of Conduct. Now, they do mention something interesting here. They mention that in fairness, this is what they say, fairness requires Mr. Murdaugh to note that Judge Newman had good reasons to believe his role in the murder trial was complete. So they're kind of giving him, an excuse. They're saying, you know, maybe Judge Newman had reason to believe that his job is basically done. Why? Because Judge Newman is retiring at the end of this year. So Judge Newman is retiring at the end of this year. So he doesn't really feel that he's going to be hearing anything anymore in this case anyway. Even if the appeal process goes on, he's going to be done as a judge anyway. And it could be, they're saying, that that's why he felt like he can talk to the news stations and he can give the interview at the law school, because he's retiring in a few months. Well, they're going to come back to him and say, you did something wrong. Okay, what now what? He's not going to be a judge. He's not a judge anyway, retired. So they're giving them, they're kind of saying, well, maybe that was his excuse for doing it, but for speaking. But at the end of the day, they quote Thurgood Marshall as saying, rules is rules, even in circumstances where it seems they do not matter. And therefore, they are arguing for all these reasons, Judge Newman, because of all these violations of the Code of Judicial Conduct, he should be disqualified from presiding over the motion for a new trial and the evidentiary hearing, and also if there's any other retrial of the murder case. So that is essentially what it is. Hopefully that gives you a good idea of what's going on in this petition for writ of prohibition, and that is that. Please, if you haven't yet, subscribe, like the video so we can continue bringing this analysis. See you next time.